When a family is torn apart, the courtroom becomes a battleground. But what happens when the fight isn't just between the parents, but between their high-priced attorneys? We are about to witness a masterclass in petty squabbling, where two lawyers go head-to-head over a few hours of parenting time. At the center of this storm is a 4-year-old child named Maggie, whose daily routine has become the rope in a vicious tug-of-war. The father's attorney argues for stability and consistency, accusing the mother of manipulating the schedule for her own benefit. The mother's attorney fires back, painting the father as a game player who refuses to communicate. As they argue over 9 a.m. versus 4:30 p.m. exchanges, a frustrated judge is forced to referee a conflict so trivial it's costing the parents a fortune in legal fees. This isn't just about custody, it's about control, and the collateral damage is mounting.
Forward. I mean, we're I'd argue over a day or 4 hours or 2 hours of makeup parenting time. It's costing these parties a lot of money. And I think we need to clarify the order regarding pickups, drop-offs, timeframes, holidays, and just move forward. So that's court's opinion. Of course, the front of the court is making it easy because the front of the court's preparing these orders. If the attorneys think there's a discrepancy in the orders, the attorney should be preparing the orders. But of course, the front of the court has been kind enough to assist the court and the parties with preparing those orders. In any event, Mr. Walker, do you have a recommendation for the court this morning?
I do, Your Honor. I haven't put it in your queue, but I can read it into the record if you would like.
Okay, let me just, maybe I need to refresh here. There it is.
The judge immediately cuts to the chase, and you can hear the exhaustion in his voice. He points out that this entire hearing, which is costing these parents a significant amount of money, is over a few hours of make-up parenting time. He mentions the friend of the court, a neutral third-party office in family law that assists the court with custody and parenting time recommendations. Here, the friend of the court, Mr. Walker, has made a recommendation, but the parents can't even agree on that. The judge notes that his staff has been preparing the orders to be helpful, a task that the attorneys should be doing themselves. This is a subtle but clear signal of his frustration. He's essentially telling them they've created this mess through their inability to cooperate, and now they're wasting the court's time and their own money to fix it.
Yes. Apologize for the delay. Maybe that Ms. Gorski, Ms. Kuhn, Mr. Chappell, the recommendation of Mr. Walker is that mother shall be told to make a parenting time of 2 hours for the time she missed on January 15, 2024, Martin Luther King Day, and that all future exchanges shall be at 9 a.m. Need to clarify the exchanges are either at daycare or, if there's no daycare, at the Saline Police Department. Is that what the court practice has been?
Yes.
Right, so perhaps we should clarify that, Mr. Walker. I'm not sure what else we need to clarify, that the all exchanges shall occur at daycare. And if daycare is closed, then it'll be at the Saline Police Department.
I will do that.
There's some disagreement as to the makeup time as well as the time of the exchanges. So, Ms. Gorski, do you want to go first in terms of what's your client's position on this recommendation?
Yes, thank you, Judge. As I've acknowledged in my response, my client believed Martin Luther King was a holiday, and so he did have the child from 4:30 to 6:30, and it was not a friend of the court holiday. We acknowledge that there were 2 hours there that needed to be made up. But with respect to the exchange time, my client is of the position that this 9 o'clock exchange is not fair to Maggie. She's been at Stony Creek Preschool for 2 years, and it is the only thing that provides consistency and stability while her family goes through this transition. And so he's of the opinion that Maggie should be allowed to go to school, and that the parties should be exchanging at 4:30 after school. What mom likes to do is go and pick up the child from school after my client drops her off. And Maggie should be in school with her friends every day. She should have that pattern and that stability. The 9 a.m. exchange time doesn't do that because mom will go and get her from school. And he also notes that school ends at 4 o'clock. We intended that Maggie go to school, and at 4 o'clock, the parent whose parenting time it was would pick her up and then go to Celine and exchange her. So we think that the exchange should be 4:30 and not 9 o'clock. If it's my client's overnight, then he should have her the next day until 4:30 when they exchange. The 9 a.m. exchange time isn't fair to the child.
This is the father's opening salvo delivered by his attorney, Ms. Gorski. The argument is framed entirely around the child's well-being. She claims that a 9 a.m. exchange time is disruptive and unfair to Maggie, who thrives on the consistency of her preschool schedule. The core of her argument is that parenting time shouldn't begin until after the school day ends at 4 p.m., allowing Maggie to have a full, stable day with her friends. She then drops a key accusation that the mother uses the 9 a.m. exchange time to pull the child out of school, effectively stealing time from the father and disrupting the child's life for her own convenience. This positions the father as the parent advocating for stability and the mother as the one creating chaos. It's a powerful emotional appeal designed to win the judge's sympathy.
The whole object is to minimize contact between the parents, which is really unfortunate to think about it. Isn't that the whole thought behind this? Is that they pick up and drop off at school, and the only time they meet at the police department is when there is no school. And is there school during the summer too? Daycare?
There's daycare. It's daycare. She's 4. It's preschool. It's an educational daycare, Your Honor. So
Right.
My client doesn't pull the child out all the time. That is such a mischaracterization. And Mr. Mansick has pulled the child out. It's educational daycare, number one. It's not state mandated, as the court is well aware.
Excuse me.
9 o'clock exchange, they drop the child off to the educational daycare at 9 a.m. The exchange is at 9 a.m. They're not seeing each other. They're only dealing with each other if there's no daycare. So yes, so we want to minimize the contact. Your Honor, I'll be filing a motion for my client to get vacation parenting time. Nothing ever occurs. These parties do not co-parent. They do not agree on anything. I had to file an ex parte motion for the child to even just go to it.
And here comes the counterattack. The mother's attorney immediately reframes the narrative, dismissing the father's concerns as an over-the-top exaggeration. She pivots from the child's school schedule to the parent's inability to co-parent, claiming she had to file an emergency motion just to get the father to agree on school placement. This is a classic legal tactic. When accused of something, accuse the other party of something worse. She's suggesting the father is the true source of conflict and is now playing the victim. She insists the real issue is simple, defining when parenting time begins and ends. By anchoring her argument to the existing court order, she attempts to paint her position as the legally correct one, while portraying the father's argument as purely emotional and obstructionist. The battle lines are clearly drawn.
School for just to even get on the placement. So you are 100% right, Your Honor. They do not co-parent. They do not agree. The 9 o'clock exchange is the perfect exchange because the less contact we have with these two at this point, the better off we are, Your Honor.
Right,
Judge, Ms. Kuhn didn't need to file an ex parte petition for Maggie to go to Emerson. My client was intending to take her. My client did take her on Friday and in fact went back subsequently for his own private tour without the child with him. He went back on Monday. Maggie's already announced that she's going to Emerson. She told my client that because that's what her mother tells her. It's over the top. But all of that aside, the issue here is when parenting time begins and ends. And I'm simply asserting for both parents, if it's their overnight, they have the next day until 4:30 at the Saline Police Department. That's what the order says, and it makes sense. This child should be in school every day. It is an educational preschool, and she is getting the benefits of that consistent schedule.
So,
Your Honor, we want to minimize contact. The 9 o'clock exchange, the drop-off occurs at 9 a.m. It's the other parent's parenting time. And with regard to Mr. Mansick's, if you look at the conversations on Exhibit 1 for the ex parte motion to even have the child go to school, you'll see the game playing. He never confirms it. And Ms. Zagorski saying, well, you should have gotten a hold of me. Well, if counsel has to sit here and micromanage, that's a clear indication that these parties.
The mother's attorney is now doubling down on her legal strategy. She points to a previous court order from June, claiming it explicitly states that exchanges occur at 9 a.m. and that there is no ambiguity. This is a direct challenge to the opposing counsel's entire argument. She is essentially telling the judge, this issue has already been decided. All you need to do is enforce your own order. By doing this, she frames her client as the one following the rules and the father as the one trying to rewrite them after the fact. Notice how she also preemptively dismisses any chance of the parties resolving this themselves, highlighting their complete lack of communication. She's not just arguing for a 9 a.m. exchange. She's arguing that it's the only way to minimize contact between two parents who simply cannot get along.
Don't communicate, don't co-parent. Mr. Walker's recommendation is a sound recommendation. And in fact, Your Honor, if you look at your order, the June order, it states that the above exchanges shall occur at 9 a.m. I don't believe, respectfully, that there's any ambiguity in that order. I'm asking that the 9 a.m. parenting time be reaffirmed or affirmed in the order that's before, that's part of that recommendation, Your Honor. It makes the most sense. It allows for the least amount of contact. My client plans on Maggie attending her preschool. So, there's been no motions before you by opposing counsel stating that it hasn't, that there's been an issue. There's no issue, Your Honor. But we would like the 9 o'clock exchange time.
This is the moment the accusation becomes specific. The father's attorney claims the mother picks the child up from daycare early, specifically on Fridays to start her long weekend. The mother's attorney immediately becomes defensive, retorting, it's a preschool daycare and that taking her out is no issue. This is a critical point of contention. One side sees it as a stable educational environment that shouldn't be disrupted. The other sees it as flexible daycare. The judge seems to side with the father's perspective, noting that most kids, even at that age, enjoy the consistency of school and seeing their friends. The father's lawyer has successfully planted a seed of doubt about the mother's motives and her respect for the child's routine. The request for attendance records is a direct threat to prove this claim with hard evidence.
Makes the most sense. It comports with what was agreed on last time. I don't believe that there's an ambiguity, Your Honor. And with that being said, I'm asking that the court adopt Mr. Walker's recommendation. Ms. Zagorski and I can go back and forth on the 2 hours. Hopefully we'll be able to figure that out. I don't have any confidence the parties will. So I can send Ms. Zagorski a 2 hour, window where my client can have 2 additional hours. I'll also be asking her about some vacation summer parenting time in May. If we can't resolve that, then we'll be back.
Again, yes, the order, and I've got the order in front of me, and it seems reference that certain above exchanges shall occur at 9 o'clock. But what's been the practice other than, of course, this order references Father's Day, Mother's Day, and some time in July 4th and July 11th. What have the parties been practicing? Obviously, it's a 2-2-3 schedule. So the parent who has a child that weekend takes the child to daycare, correct?
Yeah, Judge.
In the morning? And the other parent picks up after daycare?
No, mom has been going and getting the child in the morning, and I'll get the attendance records. Dr. Wooten has them right now. I will get the attendance records and I will submit them to you with a motion to have her stop taking this child out of school every day. What she does is she takes my client's time. She just goes and picks the child.
The argument now descends into a granular debate over the literal text of the court order. The judge is reading it aloud, trying to parse the language. It states exchanges occur at the child care facility, but if there is no child care, they meet at the police station at 4:30 p.m. The mother's attorney seizes on the first part, arguing the exchange is implicitly at 9 a.m. drop-off. The father's attorney focuses on the second part, arguing the 4:30 p.m. time should apply to establish the end of the school day as the real transition point. This is a perfect example of how poorly written or ambiguous orders fuel endless conflict. Each side can cherry-pick a phrase to support their argument, leading to a stalemate that only a judge can break. The core problem is that the order never explicitly defined what happens between 9 a.m. and 4:30 p.m.
Child up from school, and the attendance records will show this. Dr. Wooten has them right now. My client does not do that. She goes and she picks up the child, so Maggie doesn't get the benefit of being in school all day because she thinks her time starts at 9. My client thinks her time starts at 4:30, and his time starts at 4:30. The child should be happy, and that's my client's concern, is that Maggie is the one who loses with a 9 o'clock exchange. Maggie loses.
Right. Does that occur every Monday? Mr. Blue does not work on Mondays?
She does that on Monday, Wednesday, Friday, I think, right? Goes and picks Maggie up.
Emily, she picks her up on Friday
Fridays
for a long weekend.
at 9.
Yes,
Okay. So she takes her out on Fridays.
but the intended,
No, and Judge,
she takes her out often.
Judge, it's a preschool daycare. It's daycare, number one. Number two,
Not
if she
daycare.
takes her out, or it is a daycare, it's an educational daycare. She's 4. She's not even.
Here it is. A direct admission from the mother, Rebecca. After her attorney has been arguing that taking the child out is no big deal, the mother herself explains why she does it. She claims it's because of her work schedule, which has her in 3 different locations, making it easier to pick Maggie up early. She tries to downplay the frequency, stating it's not every time and that she communicates it, but the admission is clear. She is in fact removing the child from daycare during the day for her own convenience. This completely validates the father's central complaint. While she may see it as a minor logistical choice, in the context of a high-conflict custody case, the other side sees it as a selfish act that disrespects the child's schedule and the father's time.
It's not even state mandated, Your Honor. She is in school on Fridays. If my client picks her up a little early for a long weekend, there's no issue. And
Well,
as I stated
So
before,
children need consistency and continuity. So what right now? So does mom pick her up just on Fridays or just Mondays or just is it random? She just picks her up. I mean,
Random.
most kids like that to see their friends. I've got grandchildren that are 6 and 4. They like their school, even though it's not state mandated. It's certainly it's more than just babysitting. It's preschool. So what is her schedule? The child's schedule right now? Is she there Monday through Friday or just?
One day.
And who pays
She's
for it?
Monday through Friday, 9 to 4, and mom
Who's paying
goes
for
and
it?
picks her up randomly. And Judge, so my client's never been happy about that. He didn't rush into court and accuse mom of wrongdoing. When we talk about co-parenting, I think it's evident what's going on here. Mom makes the rules however she sees fit. And so this kid is the one who loses.
that is so
So
not
that's
true.
I'm trying to understand the past practice. For example, if it's dad's weekend, then dad takes the child back to school on Monday morning, correct?
9
Yes.
a.m. And then it's mom's time. Exactly. The exchanges have been at daycare at 9 a.m. That's what we've done.
But that's not an exchange. That's dropping the child off at school. The exchange per the order is at the Saline Police Department at 4:30. The intent was that Maggie would be in school all day. She gets out at 4 and then my client could drive her to Saline in 30 minutes.
Mr.
That
Gorski,
was the
read the
intent.
order. That's not the intent. Exchanges shall occur at child care facility. If no child care, parties shall meet at Saline Police Station at 4:30. The
Correct.
exchanges occur at 9 a.m.
The hearing has now devolved into a dizzying spiral of confusion. Both attorneys are talking over each other, trying to explain their interpretation of the day. One believes the parenting day starts at the 9 a.m. drop-off. The other believes it starts at the 4:30 p.m. pickup. The 7.5 hours in between have become what one attorney calls the abyss, a black hole of time where neither parent agrees on who is in charge or what's best for the child. This is the tragic result of their conflict. A simple school day has been weaponized. The judge is trying to apply logic, but the parent's inability to communicate has made logic irrelevant. Every potential scenario, a sick day, a holiday, is another potential fight. The focus is no longer on the child, but on winning the argument.
If there's no child care, then at 4:30, there's always child care. It's a child care facility too. Your Honor, 9 a.m. makes sense. My client doesn't need to meet Mr. Mansick. Mr. Mansick can't even give her a okay to take the child to Emerson. Look who's playing the games. We don't want to put these people together more than what we have to. If we're exchanging at 9 a.m., if you want my client to say, okay, she will be in daycare, she will pick her up after daycare on her days, you'll do that, correct?
Sorry for clarity. What do you?
So not pulling her out early, even though it's daycare. You'll leave her in daycare Monday through Friday on your days, correct?
On my days?
Yes.
But, so because of my schedule, a lot of times, every time I took her out early at 9 a.m., I emailed Mark through AppClose, and that's what I would do. I wasn't hiding it. I have to sign in when I would do it. A lot of times for me, because my job is in 3 different locations, it's easier to go pick her up.
But can't
at
you
2
stay in
o'clock.
until, so you were only taking her out for 2 hours early?
Yeah, sometimes it was just 2 o'clock. I would run over there because of
Get her?
of other things. It's not, the only times I took her out at 9 a.m., around 9 a.m., Mark received some kind of communication.
How late is the daycare facility open until?
6 o'clock.
So really it ends at 6 p.m.
Mhm.
So if you're taking her out at 2, it really ends at 6 p.m. anyway. And you're all taking her out at 4 anyway. So that's the time that you've chosen to
And
take her
time,
out.
4 is the time Mark chose. Sometimes I pick her up at 4:30. Sometimes I picked her up at 5. It depends on my schedule. My schedule
All
has
right.
always been different.
All right, thank you, Mr. Voot. We've got a very busy morning. It appears that if the daycare's on mom's time, she should be able to take the child out of school. And then likewise, dad. If dad wants it's a nice day, wants to do something with his daughter, it's his day, and he should be able to do that. But it does appear that all change should occur at the child care facility. So who's ever got the weekend, they take the child to daycare Monday morning, and then daycare begins at 9 o'clock, whatever time it begins. So do we need a specified time? It seems like the only time we need a specified time, and maybe I'm missing something. The only time we need to reference a time frame is when there's no school. And it appears that when there's no school, it should be at 4:30. Am I missing something?
No, that's what the order says.
The judge has had enough. After listening to the circular argument, he takes 2 decisive actions. First, he references a prior mediation scheduled for June, showing this isn't their first attempt at out-of-court resolution. Second, and more pointedly, he orders both parents to complete a high-conflict solutions workshop. This is not a suggestion, it's a judicial order. By mandating this, the judge is officially labeling their behavior as high conflict and forcing them to get professional help on how to co-parent for the benefit of their child. It's a clear signal that he believes the problem isn't the wording of the order, but the parents themselves. He's telling them in no uncertain terms that they need to learn to act like adults before they come back to his courtroom.
Judge, I think the controversy is in those hours between 9 and 4:30.
And if it's mom's day, if mom's day, if she wants to take her, if she's got off work, and she wants to spend time with her, take her to lunch, she should be able to do that. But then she takes the child back to daycare so that whenever it's dad's time, dad can pick her up, whatever, at the end of her Tuesday schedule. But then court's inclined to simply suggest that with all exchanges occur at the child care facility, and if there's no child care, why should we leave the Saline Police Department at 4:30?
Or 9 o'clock, Judge. Judge, we can meet at 9 a.m. in the morning too. Why don't we just keep it all 9 a.m. since we have to keep coming back on these issues? My client can meet Mr. Mansick at the Saline Police Department at 9 a.m. and we can do the exchange.
Would the child be at Miss School? Would the child be going to school?
If there's no school. If there's no school, Judge. If there's no school, we can still meet at 9 a.m.
So the issue, Judge, is if it's, for example, Mark's overnight on Tuesday and he drops Maggie off Wednesday morning, whose day is Wednesday? Rebecca thinks that her day begins at 9 a.m. and Mark thinks her day begins at 4:30. It's that at 4, you exchange at 4:30. It's that, 7 hours in between that is the abyss. Rebecca thinks that that's her day, so she can go remove this child from the facility. Mark thinks that the child should be in the facility all day and that it's Maggie's time at school and that the exchange time is actually 4:30 and not 9 a.m. Do you follow me?
How confusing for all of us.
Yeah, yes. But that makes no sense. If the exchange time is 9, that means the parent who has the child at 9 a.m. is responsible for the day until the next parent exchange. That makes no sense, Maria. I'm sorry. But if the exchange occurs at 9 and it's mom's day and it's her parenting time, she's responsible for that day. When she brings the child back for dad's exchange time, he gets the whole day. So exchange time at 9 means the parent who is coming into possession, that's their parenting time.
They come into possession at 4:30 and they get 24
At
hours.
9.
4:30 until
At
4:30.
9.
Until 4:30.
No,
No.
Ms. Zagorski, if at 9 o'clock, if the child's sick and the parent whose parenting time it is, they're going to call that parent and say, your child's sick, come pick her up. That it's 9 o'clock is the exchange time. So mom would be responsible for the time that the child is in school during that time. The exchange time is 9. I don't understand why that's so difficult. It's very simple.
Because Mark or Rebecca is going to take the child to childcare at 9 a.m. or
Yep.
keep the child until 4:30 if there is no
No.
childcare.
9
It's
o'clock.
her day because it was her overnight the night before.
That's why I'm asking that the 4:30 not be 4:30, that the parties exchange. If there's no daycare, they exchange at 9 a.m. If we make the 9 a.m. time consistent with whether there is daycare or there isn't daycare, we don't have that issue. That's why I'm asking, Your Honor, if we can not do an exchange at 4:30, if we can just do all the exchanges at 9 a.m. If there's no daycare that day, they can meet at the Saline Police Station and it's a 9 a.m. exchange. If it's Mr. Mansick's parenting time, he has her all day.
My client is asking that the child be afforded a consistent schedule and be permitted to go to school, that the parties exchange at 4:30. And that's what the order says.
If there's no school, she can't go to school.
And then
That's my
she should
point.
stay
If there's-
with the parent in whose home she woke up. So if there's no school and she wakes up in Mark's house, he should have her until 4:30 that day.
He should exchange her at 9.
If she's sick,
If we,
she should stay in the home where she wakes up until later that day.
both parents, I'm sure, are capable of caring for a sick child. Your Honor, I would ask that you adopt the recommendation and that the exchange time be consistent, or we're going to be back. If we do a 9 o'clock exchange time, either the child's going to our educational daycare for the day, or if daycare is closed, they're going to be with the other parent. It just makes sense.
I will get you those records, Judge. Ms. DeVoot does not allow this kid to be in school all day. I'll get you the records.
Get the records, Ms. Zagorski. I'll get them too. So that is such a mischaracterization.
All right. Do we need to talk about the 2 hours? I mean, I don't want to come back next, in 2 weeks to talk about the 2 hours. Let's address the 2 hours of makeup parenting time
2 hours.
today. And let's talk about summer parenting time today. So I'm going to have you talk with Mr. Walker about the 2 hours and summer parenting time. Lastly, the parties were mediated with Mr. Godfrey February 19th. What happened with that mediation?
Judge, we're waiting on Dr. Wooten's recommendation. It was rescheduled to June 4th.
Okay. And Mr. Walker, the other thing, the court's can order that both parties complete the high conflict solutions workshop. It's they can do it online. It's one word, high conflict solution. It's co-parenting, and I've heard good things about this program. Perhaps it would assist for the benefit of the minor child. So I'll come back and I'll consider this recommendation of Mr. Walker, but I'd like the parties to agree upon. Let's say tie down those 2 hours today. Let's talk about summer parenting time. It's March right now. Before we know it's now obviously the daycare, that's year round, correct?
Correct.
Yes.
But Ms. Gorski, the court's opinion is that yes, if the child's at daycare and maybe it's a beautiful day and mom or dad wants to do something, it's their day, they should be able to take that child out of school. Even though I agree that child needs to be primarily consistent in terms of going to school, but there should always be exceptions to that, some flexibility.
Well, sure. So if they wake up and they want to keep Maggie home for the day, they should be able to do that. That's what I'm saying. They keep her home and then exchange her at 4:30. I agree.
Okay, let's have Dr. Mr. Walker about the 2 hours. Let's tie that down as well as the summer.
Okay. Back to the breakout room.
Yes, please.
In the end, nothing is truly resolved. The judge, clearly fed up with the bickering, sends the attorneys and parties into a breakout room with the court official, Mr. Walker. Their task is to sort out not only the original 2 hours of makeup time, but also the entire summer parenting schedule, a task that seems monumental given they can't even agree on a single day. The judge made his opinion clear. There should be flexibility, but the parents' constant conflict has made that impossible. They were ordered to a high conflict workshop, a stark indictment of their inability to put their child first. We leave them as we found them, locked in a stalemate, with the well-being of their 4-year-old hanging in the balance. What do you think the judge should have done? Should he have made a strict ruling, or was sending them to negotiate the right call? Let us know your thoughts in the comments and subscribe for more courtroom breakdowns.